Now that we're talking about how to answer questions, we've learned about issue, rule, analysis, conclusion. We've learned about taking the law or the rule from any one case and then applying it to our facts and using other cases and using their rule and seeing what the result was there and comparing to ours. So today we're going to talk about what words you are using to talk about the test from each case, the rule. And what we're going to do is look at how you've been taught all these years as students not to plagiarize, not to use other people's work. But with the courts, you actually want to use exactly their words. Because as soon as you start to summarize or use shorthand terminology for what the police were doing or what the defendant was doing, at that moment, you've stopped applying the law and you're applying a different rule. You're making your own rule, essentially. So it's actually a really easy thing to do once you know that this is what you're supposed to do, is to use the exact wording from the cases to state the rule, and then apply that to the facts in our case. The usual test under the case law for Fourth Amendment is whether someone's under arrest or in custody. The test is whether they are, quote, free to go. But none of our cases have that in their language. The 2022 case packet has a case called Castaneda. It's a California Supreme Court case in which someone is deemed to be in custody if the police were moving them around and had them handcuffed. So what we would do is use the Castaneda language. The police were taking them around and the defendant didn't feel that they could do anything but comply. We would use the exact wording from the Castaneda case as the test, instead of using the test that's used out in the real world by attorneys, which is free to go. I also want to talk about when we go ahead and use the wording from the cases, we are putting ourselves into this structure that is using the court system and the justice system in the way that it is set up. So this would be working within the system to try to do the right thing, to represent your client, to represent the state if you're on the side for the people. If you're following exactly the laws that exist, you're working within that system. So over decades and centuries, we in America have tried to figure out how to effect change. And this is only one way to effect change. Working within the system is not the only way. So I would invite you to explore and keep your mind open to seeing how we make change differently out in the world, other than through this system where we use the same wording. So it can be a bit galling to use their language, but if we're working within the system, this is how we would be trying to argue that this is a convincing position for our client under the laws that the judge who's sitting is bound by and professes to be bound by taking on that robe and going ahead and hearing cases within the system. I'd invite you to think about how and why we have laws. In my own view, I believe that people who lived in caves would come out one morning and see people coming from another distance, another direction, that they didn't know who those people are. And so everybody, any given situation, had to decide what's going to keep me safe, what's going to protect what we have. Couldn't we work together with these people harmoniously? Do we fear these people and we have to fight? You're in a situation where the ruling power structure simply will not listen to someone of your type, whether it's gender, race, color, you name it. You're going to have a really tough time working within that system. Does that mean we quit? No. But it does mean that we need to be aware and hope to work within and without externally on these power systems. So that's my 2 cents on thinking about all the language we use. The good news is the justice system is supposed to evolve with our awareness and our mores. For example, Ruth Bader Ginsburg, working on all of the cases that she did through her career before getting on the Supreme Court, and then of course on the Supreme Court, explaining how, yes, this is the law, Your Honor, but taking it to the Supreme Court and saying society has evolved to a point where if I'm a woman trying to get a job and feed my family, that shouldn't be stopped by the man next to me trying to have a job and feed his family. As she argued famously, take your boot off my neck. It can be daunting as you work through the system to have the setbacks where certain judges apply laws in a way that they are clearly disregarding what's come before them, and they make up some pretense to come out the way that they want the case to come out. Whether it's saying that they're implementing the founding fathers' mores, I mean, that was 200 and something years ago. Our modern society was nothing that the founding fathers would have ever contemplated. Free to leave notes in the comments as to your thoughts on this. Welcome the feedback.